Dr. Khaminwa. We also celebrate you and honor you for the work you have done in the profession. You have mentored many, many lawyers, and you have really defended the Constitution and the rule of law all your years. And for us, you remain our symbol of unity in the legal profession. So thank you very much. We appreciate you also. So this time now, I will ask my colleagues to seek clarification from the submissions so far made by the third appellant and all the respondents who are opposing the first and second appeal. Judge Ouko.
Thank you, Judge President. Thank you, Counsel. I've got a couple of questions, some clarifications. I'll start with Mr. Harvey. Once again, on basic principle, basic structure, would you say that the holdings of both the High Court and the Court of Appeal give sufficient guidance to the citizens of this country on how to go about this? Does it tell them what provisions are secured, which provisions will not offend the basic structure? Because looking at the decision by the High Court, it seems that from the preamble to all the 18 chapters, including the 6 schedules, are no-go zones. The Court of Appeal, affirming them, but with a bit of modification, seem to say that the entire Constitution actually says the Constitution itself and all that it contains. The same court seems to suggest that yes, there is basic structure, but it's codified or enacted in 255(1). And that for you to touch it, you must go through some 4 sequential steps. But these steps are not spelled out by the court. So the question is, have we guided as a judiciary, as courts, the citizenry sufficiently to know how to go about this in future? The second one is related to the 4 sequential steps. What is the basis of this? Is it part of the procedure contained in Article 255(1) to 11? Is that can we find it there, these 4 sequential steps, or is it something we picked from somewhere else? That will be it for Mr. Harvey. My next question is to Ms. Kituku for Muhuri. The attention of the High Court, and I believe that of the Court of Appeal, was drawn to the fact that there are certain actions that had been taken by IEBC by the time they were being told that they were not properly constituted. For instance, there were 30 by-elections that had taken place, and I dare add that even the election of the President of the Court of Appeal was done during this period. What is the status in law of these actions that were taken when you said the commission was not properly constituted? My lady, that's all from me.
My first question goes to Mr. Murare Omoke, as well as I think Ms. Angawa and perhaps Ms. Kituku, who talked about the quorum and the issue of minimum and maximum membership in the Commission. In the Constitution, there are express provisions for quorum, for Parliament, for the impeachment of the President, for the Supreme Court, and when you come to the chapter on the counties, the legislation for counties must provide for quorum. Then there are other institutions or agencies like Cabinet, like the commissions, where they prescribe a minimum and a maximum. This is different from quorum. You seem to suggest that quorum ought to be read in to the Constitution, whether or not there is legislation. My question then would be, for what purpose then has the Constitution stipulated a minimum and a maximum? What is the purpose of putting in a minimum or a maximum? What do those words mean? My second question goes to Mr. Ongoya. You know that this matter has come to us as an appeal as of right. And I wasn't sure that, it seems to me that you're suggesting that where there is a question of constitutional interpretation, which is pegged on the actions of a state agency or body, then we, on second appeal, would be bound by the rule of factual limitation on a constitutional question, constitutional interpretation. I just wanted you to clarify that. Finally, to Ms. Kituku, you've suggested that the IEBC, the public participation was not enough, the use of the website. What would you be suggesting could be a method that the IEBC could use in order to reach the Kenyans who you say were not reached? Secondly, I wasn't clear. You talked about evidence that there is no participation in county assemblies. Then you said that the county assemblies have not participated in this case. I was hoping that you could perhaps point to us on record the evidence that shows that there was no participation at the county assemblies, just to clear up the point you're trying to make. Thank you.
I think I can follow that up by seeking clarification also from Ms. Kituku on the question of public participation. And we all recognize that there was no legal framework to guide the process of public participation. My question is, in the absence of this legal framework, does the Constitution allow some broad parameters that can be used for public participation? And if so, what are they, and how can they be measured? The other one is also a follow-up, maybe to Dr. Khaminwa, and this is about the basic structure. I'm happy you are now calling it the principle, because I've been wondering in my mind, when does a doctrine become a doctrine of general usage under the common law or under the international law? But now you say even judgments from the Commonwealth can be elevated to the same level as the international law that is applicable in Kenya as per Article 2(5). Those principles are jus cogens, known as jus cogens. I'm wondering, at what stage does a judgment of the court get elevated to that status? What does it go through to be elevated to that status of principle of general application under the international law. And I'm looking at the case of Kesavananda, which was before our constitution, and wondering whether it had actually informed our constitution because of the preamble, the Article 2, and the Articles 255 to 257 and other articles on human rights. That would be my clarification on that. Judge Wajara.
Thank you, Council, for your submissions, which will go a long way in aiding us to arrive at a reasoned judgment. I seek clarification from Mr. Harvey. Yesterday, you consistently appeared to draw a distinction between amendment of the Constitution and alteration of the Constitution. And then you did state that when it came to the Constitution of 2010, the word alteration disappeared. Did it just disappear? Or could it have been the intention of the framers of the Constitution? And why do you think it disappeared? And if it did disappear, independent of the thinking of the framers, how would this court resuscitate it in a constitutionally interpretative manner? Then all of us, I think, have been told about the 4 sequential steps which would then legitimize any intended amendment to the Constitution. And I think, Mr. Harvey, you can again weigh in on this one. The idea of constituent power, where and how do you locate the juridical form of such constituent power? And then finally from me, I go back to ETOPS. Let's get back to ETOPS. I have a feeling it could become a doctrine in future also. So this is then Ms. Angawa and maybe Ms. Kituku. Let us, for purposes of argument, say that Parliament, in conformity with the minimum of the composition of IBC of 3, that Parliament, for the sake of argument, enacts a law to give effect to that minimum, and indeed sets the composition of IBC at 3, and goes ahead to set a quorum of either 2 or 3 on the basis of that minimum, would that be bad law? That's all from me.
Thank you very much, Mr. Lesinko. If I heard you correctly, you said that the Indian Constitution protects eternity clauses from amendment. Where is that law that says so? What are these eternity clauses? Because if you look at Article 368 of the Indian Constitution, Parliament can amend any article of the Constitution, including 368 itself. But there's a procedure set out in 368. Interestingly, in fact, in India, no court can attempt to challenge, can attempt to overturn any amendment by the legislature, including the state legislature. So where do you get this? What are these eternity clauses that you're speaking about that are not amendable? Where do you get that from? Mr. Harvey, in follow-up to the questions by my 2 colleagues, at paragraph 1289 of Kesavananda, the judges are saying the history of India and learning from experiences of other countries have endeavored to make their constitution as precise and as detailed as possible so that one need not depend upon judicial interpretation to make it survive. Correspondingly, they are made flexible so that there is need for amendment can be done. In that context, looking at Article 255, and I borrow this question from Senior Counsel James Orengo. If indeed Article 255 does not contain clauses that would not require amendment, and that under 255 you can actually amend all the clauses, what other clauses, what other matters, because 255(1) refers to matters, and I'm asking myself the question, under 255, it says if the amendment relates to any of the following matters, then those matters must be taken to a referendum under 255 or 256. Now, what are the matters outside the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, national values, Bill of Rights, term of office of the President, independence of the judiciary and commissions, functions of Parliament, devolution, and in fact, the provisions of Article 255, what other matters would you foresee as not requiring an amendment through a referendum to which we must then defer to the primary and constituent power? What sort of matters are we thinking through? So that, because it's not enough to say, let the courts decide. We must understand as judges, as we sit here today, there are certain matters that you're saying are reserved for us. What matters are those in your thinking? Mr. Dasa and Ms. Kituku, the questions have been asked by my colleagues about Article 250 sub Article 1. But I want to reiterate the question by putting it this way. No provision in a constitution like ours is placed in vain. So that I think in answering my colleagues' questions, tell us as a constitutional question, what is the purpose for 250 sub Article 1? I had arguments that IEBC can do some matters administratively. IEBC can do some matters as a matter of constitutional mandate. Now, explain to me what it can do under 250 sub Article 1 with the minimum of 3. Thank you, Chief Justice.
Thank you. I think we'll follow the practice of giving you 3 minutes to respond.
My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes.